I wasn't sure anybody would still be awake for this. Part of me was like, let me just get it out. And the other part of me was, oh, just record it, put it up tomorrow. But some of you were still awake. And so I thought, well, may as well do it. Then I don't get that feeling like something's not finished going on in the back of my head. So anyway, sorry guys, I'm not a very like stick to a schedule person. I really admire people who can do that. Um, my life outside of YouTube is very hectic itself, and so it's hard to plan for things. But oh, good morning, India. How cool is that? So let's talk about this episode. I don't know if anybody caught this. I haven't had time to watch too much out there or read too much. I pop in X from time to time just to see what's going on and stuff. But I'm not sure anybody caught this thing that happened. Apparently it happened back in July, but this is the first time I've seen it in a document. So I don't know if it's the first time it was mentioned or if it's just the first time I was aware of it. Well, hello, Australia. But what do you do when you're given something that you shouldn't have as counsel? Something from you put in your discovery request and you get a batch of stuff and you start looking at it and you realize, uh-oh, this might be privileged. So what are you supposed to do in that situation? Because that's the situation that actually happened. So we're going to talk about that today. We're also going to talk about how, when it comes to Katie Case and Brianna Koslow, we have been hearing their names over and over and over again. I don't know if you guys have noticed that, but these are employees. Well, Katie Case has left TAG. She was there during the time of the whole crisis PR situation. We hear these names over and over and over again, but they're not defendants. They're not named in the actual lawsuit. So what is going on with them? I'm sure you guys have thought that's strange too. And just these past couple weeks, there have been, I should have counted, so many filings exclusively about them. Now they have had the Wayfair attorneys do some things on their behalf, but they do have their own attorneys as well. So we're going to hear from him today. That's Maxwell Breed. And well, let's just get started with it. So like I said, Blake has been like going crazy trying to get their information, asking for it, compelling it. She doxed a bunch of people in her efforts to get it. And so it seems like, what is it? Was there something from Jen Abel's extracted phone that made her think there's something there? What exactly is going on there? We've also seen Blake, as it gets closer to the end of discovery, we've seen her getting more and more desperate. We've also seen quite a few things that were given for discovery. They've now crossed over into the public filings because of these motions to compel, because of these issues that were found with the things that they had asked for, that they said, oh, this wasn't good enough. Request for production, that's what I'm trying to think of. So normally we don't get to see this much evidence this far ahead of a trial, but we are getting to see. And one thing I've noticed, we had that huge dump of text messages and emails that we've all been devouring for the last couple of days. At least I know I have, and I think most everybody who regularly gets stuff off the docket has been just devouring these things. And if I would have guessed, like if I hadn't seen the letter, if I had only seen the actual exhibits, I would think that they were for Team Wayfair. Because the stuff in there just, I feel like it's not helpful for Blake at all. It makes her look mean. It makes her look bad. We see the pain that these people were going through at her hand, and the stuff that's coming in. And as hard as the Blake fans are trying to pretend that there's some big gotcha moment in there, I had someone send me some things on Instagram, and I was like, you've got to be kidding. So if any of you were worried because of their big talk saying, oh, right here, this is it right here, no, don't worry. And I put a link earlier to Not Actually Golden's latest video where she covers it. And this has been her field, her specific field. And she said she's done this for over 20 years. So I completely trust when she's talking about this type of law, I trust her expertise. We don't always agree on like our opinions of things, and that's fine. I mean, no two people agree on everything. But as far as her absolute expertise, I don't think there's anybody. Well, Little Girl Attorney, those two, when they speak specifically about laws, you can trust what they're saying, even if they have to be careful what they say about a judge, even if they have a different viewpoint of the law because of their field of employment than we might have. That's okay. But when it comes to the expertise, they're like no others. I think that's just my opinion. But anyway, she talked about whether or not these things seem like official claims. And then from there, then you have to also prove the retaliation. So she's done a whole series about sexual harassment claims. She's done a whole series about retaliation. And so I think those things can be really, really helpful, because when you see something like they say something about a claim, oh, was that HR? Oh, this, those are not the big gotchas that they're trying to make you all think that they are. The Blake fans, I mean, and she clears that up. So besides that, in these letters we're going to go through today, so specifically today, we're just going to deal with Case and Koslow. But there are some really good lessons in there about certain things that come up that don't always come up in every case, that we can learn a little bit about, like procedure and stuff, that have to do with evidence and evidence gathering. And we're going to learn an expression called claw back. It doesn't sound like it, but it is an actual legal term, and that comes up in here. So we're going to talk about that. So let's get right on into it. It starts off simple enough. Now, I went back to August 12th. And I mean, it's certainly not when all of this started, but it's when these recent documents that we're going to go through today started. So this was pretty simple. This was just Kevin Fritz, and I think I talked about the document before this already in a previous episode, but what had happened is they had asked for all of these requests for production. They said, you didn't give us this, you didn't give us that. There was all this stuff in the omnibus. So this is the response specifically about Case and Koslow. So what happens here is you have two different sets of counsel. You have the Wayfarer counsel, and that's what this letter's coming from Kevin Fritz. But they can't just answer for Case and Koslow, because Case and Koslow have their own counsel. So in order to give this reply, these two have to meet and they have to decide, because they're both involved in these text messages and emails, but they have different counsel. So it takes longer than if you're dealing with someone that's only represented in your firm. So that's why he's saying we've got a couple of issues here. There's attorney-client privilege. There are other privileges like work product, and these two different sets. So he asks for an extension of time. So that one was pretty simple. And then we end up with also a letter, and this is where we get a little bit more information. This letter comes specifically from Case and Koslow's attorneys. And the main attorney for this letter, at least, is Maxwell Breed. So he breaks down a little bit more, and he wants to oppose the motions to compel because of privilege. So he lists 2 documents here, but he says that, and one thing I like about him too is he's got the same spicy wit that I feel like all of the Wayfair attorneys have as well. Just they've got a way with words. They can just, without being nasty or aggressive, they can make a point. And I absolutely love to see that. I think it really spices up and makes the document so much more interesting. So he says, Miss Lively, a public figure of substantial means, demands privileged attorney-client and work product communications, and then here's the cut, hoping to come up with evidence of a non-existent and ultimately non-actionable smear campaign. So everybody is saying it in every reply, whether it's Case and Koslow's attorneys or any of the Wayfair attorneys, or if it was us responding about our subpoenas, everybody's saying this over and over and over again. And I just wonder, at some point, is Blake ever going to realize that this is true, that it's non-existent, that Miss Lively claims without support, and that's true. She has yet to show any evidence that this smear campaign existed. Even that huge dump of text messages that we're all going through, we see so many events that were completely organic. And we see these people talking about it. And they're talking about it in the confines of message groups that they felt were safe to speak in. These are all forensically extracted. So there's no altering them. This is what they were honestly saying at the time. And you can see by their reactions to it, even they're surprised about what's happening. This is organic. This was really, truly happening. So Miss Case and Miss Butler Koslow are shielding under claims of privilege. Counsel for Miss Lively should be aware, even from our non-party productions, that our clients were not involved in any smear campaign, and that the few materials withheld are privileged. So they're saying, we gave you everything except for the things that fall under privilege. And then we see some bad behavior again. Miss Lively's counsel did not meet and confer with us on many items raised in their papers. Now remember, according to the judge's individual practices, that's his rules for his court, he says, don't bring anything to me unless you've tried to work it out. You had to have met and conferred and been unable to come to a solution yourself. And there may have been some things, but they're letting the court know. And I love how they're letting the court know now. Like, you're being lied to, sir, over and over again. A lot of us are getting the chance to say that to him. So they're saying a lot of these things in her letter, we never met and conferred. So these shouldn't even be in front of you, sir. And then he says, had they, another little stick, their false assumptions would have been corrected. So he's like, they're bothering you with this, when if they had just come to us in the first place, we wouldn't even be here. So they also mention, we will be providing an expanded privilege log in coming days. We're going to talk about what that is in just a minute. I'm going to say this last sentence. As I love this so much. As this docket needs no more vitriol or hyperbole, we respectfully correct the factual record below. The vitriol, I feel like, always comes from Team Blake. They're just nasty. They don't have the wit, they don't have the spice, they just have the hate and the meanness. So they're going to correct this. But before we look at that, we're going to look at the footnote. The footnote says the wayfarer parties seek to review communications with overlapping claims of privilege. So there's different types of privilege, and there's two different counsel working on this, two different sets of counsel working on this. We will therefore confer with them regarding their claims of privilege as we finalize our revised privilege log. So what is this privilege log that they're talking about? Back in May, when this case was still new and fresh and exciting, and now it's just exhausting, but we got this document and none of us really covered too much. I covered just a small section of it to show you guys what the Bates labeling is. But this, we have the federal rules of civil procedure, then we have the state rules that they have to follow, then we have the individual practices by the judge, and then we have this. This is where the two sides come together, and according to the rules that they all have to follow, they come up with additional rules of things that might come up during the process of the lawsuit. And if they come up, this is how they intend to handle it. So that's why we didn't dive into it, because it's just like boring procedural rules and things like that didn't really mean much at the time. But today we're going to go through two things that were on here. So the first one is this privilege log. So if a document is withheld, it's supposed to be identified on a privilege log. So a privilege log is like an inventory kind of idea. And so what it has on there, it has a log number, it has a date, it has the people that are involved. If it's an email or text, it's who sent it, who received it, and then a description of contents. So you don't want to give too much away that it breaks the privilege, but you don't want to give too little that the other side can't challenge it and say, well, that doesn't sound like it needs to be privileged, because they do have the right to challenge, and that's what they're doing in this document. They're challenging privilege. So they're supposed to, both sides are supposed to have these privilege logs that they provide to each other. And then if they say, hey, I don't agree that this is privileged, then we have what we have right now. But this is the rules that they've decided how they're going to deal with these things. So we're going to see one a little bit later. I'll show you what it looks like, because they do this one they're talking about that's updated. They do provide it in a later filing. So let me look at my notes real quick. Okay, so in the background of this document, this is back to the one that's put out by Max Breed. So they talk about the June 24th order. That was the order that was given after the hearing that they had, because they're still fighting over this. But back in June, they actually had a hearing about Case and Koslow. So it wasn't an actual order that came out, a whole file. We just got the little pacer notes here. And so this was about, like I said, this fight has been going on all this time. So they're saying the judge gave us these instructions back on June 24th. So after that, we coordinated, we got a team together. So when they give a subpoena, for example, for these text messages, it's defined, we've already seen where it's defined by date. So it's only from this date to this date that you can ask. In addition to that, they don't get every single text message that you sent to every single person when you subpoena. Now, Stephanie Jones and Blake Lively did get that from Jennifer Abel's phone, but that is not the correct way that it's supposed to go. You are not supposed to get the entire contents of somebody's phone or even all of their text messages. you get these search terms. So amongst the text messages and emails from this time to this time, any that mention anything in these search terms, that's what they get access to. So they went over those search terms. They got a whole team together. They went through, they got everything, they sent it. And here's another little jab that I thought was funny too. Despite the delay in Miss Lively's deposition, the professed basis for expedited review. So remember, Blake had her deposition was scheduled for the first time, and then it got moved, and finally on the third scheduling it came. But she wanted all this stuff. She's like, I need this stuff for my deposition. So they all rush to do it. They pay a team to do it, and then she fails to do her deposition 2 times, and then finally does it on the third. So they're making sure that gets mentioned, which is really cool. But we made the vast majority of our production on July 16th. So they gave this to them a month ago today. Miss Lively's counsel then identified potentially privileged communications and inquired whether their production had been intentional. So this is the big issue that we're talking about today. So in this rush to get her all of these things by this deadline because of her deposition, they inadvertently put privileged things in there. So what does that mean? This stuff that they were never supposed to see got sent, and when they send this stuff, they tag every single attorney involved. So every single attorney got a copy of privileged communications that none of them were supposed to have or see, which is a big deal. It can wreck your whole case. So they let the team know, you sent this stuff, we think you sent it by accident. And so Case and Koslow's attorneys, this is where we see this term, clawed back. We investigated, clawed back certain materials and reproduced on July 19th. So this is an attorney's nightmare, that they have handed over things that the other side was not supposed to see, especially if it's something like work product, which means it's like your plans, how you want to carry out the actual trial. So it's, in a way, it's worse than some of the other stuff, because it's like you're thinking, you're reasoning, how you want to fight this in court. So so when did this happen? It happened July 16th. So I don't think that this has come up. I don't think it's come up before, or it's, at least it's the first time I've noticed it, but I feel like this is new, because I feel like somebody would have caught this before, but we just found out because of this document that it happened, even though it happened last month. So, and then he says, although hundreds of records were clawed back, that figure is knowingly misleading, as it includes artifacts embedded in text chains. Fewer than 75 text conversations, each a 24-hour period of messages containing a hit on a search term, were clawed back. So they're saying they've got hundreds in quotes, because Blake's team has said, we know you've got something more out there that you're holding back because you clawed back hundreds of records. And they're telling the judge this hundreds is an exaggeration, and they know it because it was text chains. And you know how when it's, for example, emails and stuff, if you keep responding to the same email instead of creating new emails, and it's a bunch of people responding and it goes back and forth, you end up with pages and pages and pages of just repeating. So if you say, well, I had 1,000 pages, that can be very misleading, because the actual new conversations might just be 100 pages. But because it's so many people responding and all the repetitions, it gives that idea. So they're letting the judge know they're grossly exaggerating how much information was clawed back. Yes, this was Case and Koslow, not Wayfair. So sorry, I'm glancing at the chat when I can, but I don't want to get myself too distracted. But if I happen to see an important question, I'll go ahead and answer it. So so down to footnote 2, it says that they met and conferred on the issue, and Miss Lively's counsel represented that they understood this fact and that there were not, in fact, hundreds of documents clawed back. So they really wanted to let the court know. Not only did they know that, but they admitted it when we met and conferred. So they are misrepresenting to the court, and they know good and well that they're misrepresenting to the court. So I really like that more and more. They're letting the judge know when Blake's team are exaggerating or doing things that they shouldn't be doing. Okay, so now we're back to that document that I showed you earlier that was back on May the 12th. This is the one I told you that the attorneys all come together and they decide what they're going to do in the event of these different things. So now we're seeing the term, and like I said, it doesn't sound like it, but it is a legit legal term. It's called clawback, and it's specifically referring to the situation, and it gives you the idea that it's a desperate situation, like you are reaching out, grabbing with your claws and just trying to pull it back. So what they decided to do, now this is based on the federal rules of evidence. We talk mostly about the federal rules of civil procedure, but this group of rules is specifically dealing with evidence. So this is Federal Rules of Evidence 502D. The production of a privileged or work product protected document is not a waiver of privilege. So what that part of it means is that normally, once something is privileged, if it gets put out in any way, it loses its privilege. You call it a waive of privilege. But they're saying in this situation, this was inadvertent. It was not on purpose. It does not waive privilege. It does not lose its status as privileged. The producing party may assert privilege or protection over produced documents at any time by notifying the requesting party in writing of the assertion of privilege or protection. After being notified, this is important, a party must promptly return or destroy the specified information and any copies it has, and may not sequester, use, or disclose the information until the claim is resolved. Upon a request, a party shall certify that the specified information has been destroyed, and that neither party nor its employees or agents retain any copies of the specified information. So this is what you are supposed to do. But because of the way things are given, see, way back in the day, you provided hard copies, paper copies. So you could go back and you could collect those and they wouldn't have them. But now this stuff gets emailed, and it gets emailed to everybody. I mean, you've seen in the documents where they're sending stuff back and forth to each other, and you see just name after name after name after name, because each team has a lot of attorneys. So this information went everywhere. And basically, it's an honor system. So these people are the ones who did the Van Zandt sham lawsuit. These people are the ones that are using their buy one, get 106 free Costco subpoenas to send to multiple states, to multiple platforms, to multiple people with multiple due dates. We're not talking about people with a bright and shiny moral compass, in my opinion. Don't subpoena me again, Ezra. It's my opinion. This is the law firm that has done all of these things. Yeah, Jane. Right. And trust me, bro. Yeah. So you have to rely on, yes, Mary, to multiple countries. These buy one get 106, this buy one get 106 free subpoena. And this Van Zandt, it's the same law firm that did that. And they have to rely on these people on their own word to say, yeah, we destroyed it. We didn't read it. And this is the inspiration behind today's thumbnail. You all saw. Let me click back to it. So this is them at their computer, not reading these privileged documents that they are not supposed to read. Tell me how much confidence you have in them being able to resist this forbidden fruit. I know I wouldn't have, let's just say I would not have confidence that that's not what was happening. So, oh, we got someone from Ireland. Yay. I want to go back one more time before it gets cold. Yeah, hopefully nothing real important or serious. But, okay. So now here's the thing. It sounds good that they let them know, right? That they let them know that, hey, we got this. We think you didn't mean to do it. But there's good reason for that, because in addition to these federal rules of evidence that's cited here, and this document, which is an agreement that they're supposed to honor when it comes to stuff like this, there's also the Federal Rules of Civil Procedure 26B 5B right here that tells you, now this is the Federal Rules of Civil Procedure that we usually deal with. So information produced. If information produced in discovery is subject to a claim of privilege or of protection as trial preparation material, which would be work product, the party making the claim may notify any party that received the information of the claim and the basis for it. After being notified, a party must promptly return, sequester, or destroy the specified information and any copies it has, must not use or disclose the information until the claim is resolved, must take reasonable steps to retrieve the information if the party disclosed it before being notified, and may promptly present the information to the court under seal for a determination of the claim. The producing party must preserve the information until the claim is resolved. There isn't one specific in New York. Some states are stricter than others, but because this is a federal court, it would fall under these rules right here. So it doesn't matter if New York State does not have specific rules to it. It still falls under these federal rules. In addition to that, there is the New York Rules of Professional Conduct that talk about this, and the New York State Bar Association of Ethics Opinions. So there are many, many, many reasons, or many, many sets of rules out there that tells you better comply with this. And there's also serious consequences if you don't, if you're caught using this stuff. you can be sanctioned. And those sanctions can end up being quite serious. In addition to things like, we usually think of sanctions as like money, but in this case, depending on what they do with the information, an attorney can be removed from the case, and an entire law firm can be removed from the case. So this is seen by the court as something really serious that should be honored, because it has the potential to destroy your case, depending on what was accidentally sent. So hopefully it wasn't anything too bad, like you guys are saying in the chat. Thank you so very much, Quintong. Oh, I love the little pearl. It's so cute. Yeah, should have been sanctioned long ago. I agree. So, and then the last little bit of these rules from this May document says that a party receiving any production that it perceives to be potentially privileged shall refrain from reading, promptly notify the sender or party whom the privilege would apply to, and return the material. Again, it's an honor system. And if you're not dealing with honorable people, it's a bad situation to find yourself in. Okay, so now we're going back to the document from Case and Koslow's attorneys. So they tell the judge as well that they met and conferred only once, and that was back on July 18th, about privilege. So they talked about that this production was accidental. It was not on purpose. And they gave the reasons why this was privileged. They justified the use of the log, and they discussed a single participant in a single withheld communication. So the footnote says that following Miss Lively's inquiry, they re-reviewed one communication at issue. So I don't know if it's something that they saw and brought up to them and said, hey, this isn't privileged. Why is this on here? I don't know how. They don't explain how this comes about, but we find out that there is one communication that they end up talking about at a meet and confer. They go into further review, and they decide that this one, even though it starts off with saying attorney-client privileged, that it actually was what did not meet the standard of privilege. And I remember when I was going through this big dump of messages, one of them at the top did say attorney-client privileged. And I wonder if that's the one they're referring to, because it was open in with all of the others. So I don't know if it was that one or if there's something else or what the situation was. Oh, I love that. I love seeing people from around the world. I'm always like, how in the world are people from so far away interested in what I have to say? It feels so weird, but also very I don't know. I just feel really grateful. Caroline says, you have a worldwide audience, Cassidy, so there's always someone awake, keen to hear your thoughts. Love from Australia. I've seen quite a few of you guys from Australia here and from Europe. McPeewee says the judge was so quick to strike Friedman's letter about Swift's DC subpoena, but is just ignoring all of these ridiculous subpoenas and playing games with Perez. Yes, he doesn't like that Perez Hilton called him out. I agree. And not just but all of us in the original 5 that filed our motions to quash, when the letters came out to dismiss them so that the judge didn't have to consider our motions to quash, that meant he didn't even have to read them. So that was very strategic what she did. So we wrote, and it lied. It said that we had met and conferred. None of us had. And then it also said that they were dismissed at this time. So that leaves it open that they could come back. And like I said before, we saw that Andy from Popcorn Planet, he was subpoenaed from a couple of different platforms. So we were suspicious by the wording that said, at this time, we thought she could come back and try to subpoena us through Instagram or X or TikTok or wherever else we might have a platform. So we wanted the judge to rule and say, this subpoena doesn't stand. And so we had filed these letters and they made it on the docket, but they were never addressed. And that's intentional because I think this judge doesn't want to rule this. He doesn't want to rule on this subpoena, and he knows it's not a lawful subpoena. So if he does read it and rule on it, then he's going to have to withdraw it. And I think he doesn't want to do that. And Ezra knows that she can't put out a document with case law or any kind of law or rules on her side to refute what we said. So what does she do? In a little footnote dealing with something else, she asks the court to deny those as moot. She gives no law for it, no reason behind it. She just says, "Oh, take this off there. I don't like it. Take it off there." He didn't, but if he had, I think we all would have written again and said, "Wait a minute. How did you ignore all of our case law and then just answer hers when she didn't provide you any legally sound reason to do it?" But he never did rule on it, but he just left it, and that leaves this subpoena still out there being reused and reused and reused. So just like you guys said, it's just crazy what's happening here. Kyle Atkins says, "Hi, Cassidy from New Zealand. Keep up the great content." Wow. Thank you. That's very cool. Okay. So back to this document. So we ended with the footnote. So the last paragraph in this page says, we discuss the waiver doctrine. So the waiver doctrine, let me find. So this is about, so after the sending party, if they don't speak up and say, we didn't mean to send that, then they're in essence waiving privilege because it's been exposed. So if they don't say, hey, this is privileged, then if they say nothing, then it loses its privileged status. So they have done that. But another issue that can pierce privilege is if you've disclosed the information to someone else that's unconnected with the case, you also can lose privilege status. So you can't have some really helpful piece of evidence tell opposing counsel, oh, no, you can't have this because it's privileged, and then go and leak it to the media. It doesn't work like that. If you shared it with anyone outside of the case, it loses privilege. So those are my Murdoch crew. You'll remember when it's in the conspiracy case, well, that's one of the claims that Mark Moore was making, is saying, well, Mark Tinsley talked to the press about this case, so it lost privilege. He talked to them about certain things, but he didn't release the video. They were trying to get out of being accused of being the ones who leaked the video. So that's another tactic that I call ugly lawyering. They will try to say, well, you did this, you did that, so the privilege is gone. And so this is what's happening right now in this particular fight about Case and Koslow. So they're letting them know right now, no, one, the common interest exception to waiver is applied. Given that the employees Tag and Mr. Baldoni share a common legal interest in defending themselves, including from Miss Lively's unfounded claims about a smear campaign against her. So they're saying all these people involved that have seen it does not waive the privilege because they're all in this together. They've all been accused of the same thing. They're accused of taking part of the smear campaign with each other. And two, the communications were protected by overlapping claims of privilege, as both individual employees and the employer entity received legal guidance. So they're saying all of this is under the same lawsuit. We're all accused of the same thing. We're all under the same group of legal guidance. So it doesn't break privilege that we all know this. All right, moving on. So we see they're not done with this yet. They are fighting and fighting and fighting. They really, really want this information. So another claim that Lively made, they've put, I don't know, it's like 6 or 7 different reasons to try to say this stuff is not privileged. So that's why he's going through all of these things. Miss Lively misstates the law on this, on that, because these are all arguments that she has made to try to say privilege was pierced. So this one, Lively suggests that privilege cannot attach to the challenged communications because they occurred before the retention of certain attorneys. And they say, no, that's wrong because it's been established that parties may seek and receive legal advice in anticipation of litigation before formal retention, and that such communications are privileged if made in furtherance of legal advice. So they could go to a firm, meet with them, get some advice before they actually retain them, but then they go on and retain them. That makes the advice they got before the retainer also privileged. And so they say that besides of that, no communications with outside counsel occurred before retention. So they're like, well, there's this rule, but even so, it didn't happen anyway, except for 2 communications between Miss Case and her father. The first withheld communications are from December 21st, 2024. So what's this got to do with her father? We're going to find out. Kyle Atkins, why have the essay accusations disappeared now? And it's all about the organic stuff, because this is what Blake cares about. This is my opinion, okay? So all this stuff had happened way, way back. She finds out from Stephanie Jones in August, and Stephanie does this all out of spite. She gives messages to Blake that she knows are going to make Blake mad. And she does it out of spite to hurt Jennifer. So all of this, because Blake's, she's getting all of this criticism. And she can't handle all this criticism. So the minute Stephanie hands it over to her, not only does it make her mad, but it's like, oh, the world doesn't hate you. You're still loved. This is all happening because of these people. And she latched onto that. Not only was it too late to do anything about that, it is notoriously difficult to win a defamation lawsuit. We saw that with how Justin's case was dismissed. And she's a public figure, so that makes it even harder. She never would have won a defamation case. And again, it was too late to even try. So what's a girl to do? Well, you can make another accusation that isn't too late. And then you can, instead of having to prove defamation, you can prove retaliation, which it's a much lower bar to prove. So that's my just my opinion. Don't subpoena me again, Ezra. That's my opinion on what happened. And that's what she cares about the most, because she knows she was not sexually harassed. So she wasn't traumatized by it. She was traumatized by finding out the world doesn't worship the ground she walks on. So, yeah, that's in a nutshell what I think. And she also wanted, I mean, just by when she finds out, she sends this, Ryan makes this letter and says, take all the blame for this. And then Justin and Jamie refuse to sign it. And then it just gets really, really awful from there. So it was just a series of unfortunate events. Each one made her madder and madder. And she wants someone to blame for all of the hate because she's embarrassed. Well, why is no one throwing out the essay? Well, they didn't do motions to dismiss. Justin wants to prove his case before a jury. He wants the evidence out there. So he didn't file a motion to dismiss. But also, I don't think the judge would have granted a motion to dismiss. He would have wanted to provide a chance. And this, not just Judge Lyman. When I say this, I'm not giving Judge Lyman credit. I'm saying a judge with this sort of case, with this many people looking, is not going to be all gung-ho for dismissing a sexual harassment case, especially one of this magnitude, because it's going to make people mad. They're going to say, at least give them the chance to get to summary judgment. Let her try to prove her case. So I think any judge would not have accepted a motion to dismiss anyway. But one wasn't filed. So they may do one for summary judgment, because at least with summary judgment, you do get to put all of the reasons before the court that everyone will get to read in a public docket. You do get to see all the reasons why it should be dismissed. So they may be willing to do a motion for summary judgment, which will be coming up relatively soon after all of this discovery and everything is done. They'll get that chance. But he may still want a jury trial, so we don't know. But the judge isn't going to just on his own just say, you don't have a case, Blake. It has to be brought to him in a motion of some type. So but yeah, like I said, I don't think any judge would have dismissed it in the motion to dismiss stage, just because it's too serious of an allegation and too many people watching. But I hope they do, even if they just do the defamation, not the defamation, the retaliation in summary judgment, and save the sexual harassment for trial. This whole smear campaign needs to go. It doesn't even need to go before a jury, in my opinion. Okay, so where did we leave off? So the next misstate is on waiver, and they say privilege was, Miss Lively contends that privilege was waived. Nope, I think I read that already. Yeah, they were all together in a legal interest, and they say no waiver when communications are engaged in the common legal enterprise with the holder of the privilege, TAG, its employees, and others involved in the PR representation of the wayfarer parties were entitled to coordinate with counsel and to pursue a unified legal strategy. So they're saying that they do fall under privilege. Crisis PR professionals routinely coordinate with legal counsel and on both PR and legal matters. None of these people were outsiders. They were all integral to the common legal strategy. If you look at the texts, you see all of these people's text messages in there. They are involved. So, and they're involved because Blake subpoenaed this information. So you can't have it both ways. And again, they still haven't learned not to use the wrong cases. They're going to get called out on it every single time. So they did it again. They quoted this case, Hull versus Schroeder, and they say, no, 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 this is wrong, because in this case that she quotes, the communications in question were not mere transmittals of information as part of a PR campaign, but related to a common legal interest. There was no legal character to the communications in question. The case cited by her does not involve situations where agents were sued along with their clients and therefore in opposite. The case law you quote has to match the legal point that you're trying to make. Oh, Christina sent me a message. Where? Is it on X or on IG? So this is the case that Blake tried to use to do her case. Hold on, you guys. Let me check this real quick. This is back in the Too Big to Fail disaster of 2008. So it's a stock market collapse situation. So this German company had borrowed $11 billion from a consortium of banks to finance a purchase. So the offer expired. The Lehman Brothers announced bankruptcy. The stock market crashed. The value of the shares plummeted, but they couldn't withdraw under German law. So that left this group holding 90% of the outstanding stock. It was going to completely destroy this company. And so they needed to restructure and refinance this debt. So they're being audited by the IRS. And the attorneys for this consortium, which is, this big group of banks, all unrelated, but part of where this loan came from. So these are the ones that Blake is trying to compare, or Blake's counsel is trying to compare to her situation. So the IRS begins an audit and issues a summons for documents to all of these banks. So they try to quash this subpoena and say, no, we're all involved in this. We should all be protected. But the court ruled against them because there was not a legal interest. It was just, let's see. Reasoning that the common legal interest or joint defense privilege exception did not apply, as the consortium had only a commercial and not a common legal stake in Schaeffler's potential litigation with the IRS. So in this case, there was money involved with these people, but that's it. They weren't part of this audit. They weren't part of a lawsuit. They had no part in this whatsoever from a legal standpoint. And this is the case that Blake's counsel has used to try to say, oh, it should be denied. But they're saying, no, this is a completely different circumstance. It's apples to oranges. It does not apply. It's not the same thing. So she's not done yet. She's still going with all of the reasons why privilege has been pierced. So now she moves on to saying, well, there's a former employee involved here, so that doesn't count. But they say, no, communications with former employees remain privileged if made to assist counsel in gathering facts or formulating legal strategy related to the former employee's work. And they go on again with these couple of cases, and these cases are directly from the Southern District of New York. The content and purpose of the communications, not the employment status, is what governs the privilege. So it doesn't matter that they're not employees anymore. They were employees when it happened. That was the purpose of these communications, still privileged. So they moved on again, saying, oh, it's not work product. And say it's just a PR strategy. But they quote another case and say the withheld materials, which include drafts of the counterclaims filed in this action, fall squarely within this protection. So counterclaims are legal strategy. They would fall under work product, is what they're saying here. And finally, the ones with her father, Kyle says, Cassidy, thanks for your opinions on my questions. I'll keep listening as I walk the dog. Okay, so thank you very much again, Kyle. Here's the thing about her dad. He's not just, oh, that's my dad. He's a litigator, and she retained him on August 28th. It's attorney-client privilege. So, and then finally we get down to, she says, well, if you're going to say all of those things are privilege, don't just grant it, at least give us an in-camera review. Now, I don't know if you guys remember, but back a couple of months ago, when Team Wayfair found out about the Van Zandt sham lawsuit, they tried to claim crime fraud exception for the security company that actually extracted the information from Jen Abel's phone. Do you guys remember that? So it's because this privilege is so hard to pierce, that is one of the exceptions if it was done in the committance of a crime. And the judge was like, no, 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 no. And he did not allow it. So he better not allow it here, because this is even sketchier. And really, there were crimes committed to take Jen Abel's phone, in my opinion. Don't subpoena me again, Ezra, or you, Mike. But anyway, so this is what they're asking. You can also get the in-camera review if there's a question about privilege. A lot of times it's work product, because work product is notoriously hard to prove. A lot of it is mental. You can't prove what's in someone's head. So they can say, well, based on this document, what it says here, I'm basing what I plan to say in court on this. Well, nobody can say, well, that's not in your head. It's really hard to prove. So it will come to an in-camera review. And what that is that it doesn't get shared with both counsel, but it gets shown to the judge. He gets to look at it himself, and he gets to decide, okay, and listen to the reasons for why they're saying that this is work product. And then he gets to decide whether or not it truly is. So they're saying, give us this chance. Like I said, he better not, since he refused the crime fraud exception for Wayfair. But I don't have high hopes. We'll see how this happens. It should probably get ruled on pretty quick, probably this coming week, I would guess. We'll see. Because at this end, this part of this, close to the end of discovery, things are getting decided pretty quickly. So, in conclusion, they say her motion's improper. It imposes additional burden on two non-parties who are not celebrities. They're not public figures. They don't make a lot of money. And the things we've produced so far demonstrate that there was no malign, there was no smear. The messages we've given you so far show that the PR plan was reactive, not proactive, and that there were no bots used. And that's what I've seen. Like I said, they take these little things of like them talking about the plan, and they take the invoice and they say, see, there was a smear campaign. I've seen that a lot on X. But they're saying it was all reactive, not proactive. And you can see that in there. Anytime they're talking about doing something, it's in reaction to something that Blake has done. It's not them going out and saying, we're going to do this, we're going to do this, we're going to do this. We're going to get ahead of her. Never. It was never that. The communications show that negative content posted by content creators was organic, driven by Miss Lively's own actions like her wardrobe choices and liquor promotion. That must kill Blake every time she sees that. As perhaps exacerbated by her counsel's aggressiveness. See, that's what's happened. That's why I did that video a couple of episodes back. I'm like, do her attorneys hate her? Because everything they're doing is making people hate her more. And that's what they're saying here too. Exacerbated by her counsel's aggressive, negative internet perception has been public discourse about a public figure and not the product of a conspiracy. And so they say it should be denied. These privileges have not been waived. They have not been affected. A camera review is not supported. Deny this. So we'll see how that goes from here. And again, that was Maxwell Breed, their attorney. And now we have Mike, Mr. Aggressive, Mr. Nasty. He sits right down and he writes 2 strongly worded letters. This first one addresses that that request for extension of time that we started with today. And he's like, a big fat no cherries on top. Don't grant this. And I'm just going to skim it. I almost like can't even hardly stand to read his stuff. It's so repulsive to me. But basically what he says is that they have no good cause to ask for this extension. He names the time of day that they filed for the extension because it was late. Forget the fact that they just dropped that omnibus at 11 something at night that didn't clear until 1 in the morning, so they lost a calendar day. And then they fought to say, no, you cannot extend this. But he's going to come and say, well, they filed this at 8 o'clock. Ridiculous. It's the hypocrisy with these people is insanity, which is why I find it's just so unappealing to read his stuff, because stuff like this makes me so mad. It's so hypocritical. Miss Lively made the Wayfarer parties aware that Miss Case and Miss Koslow's productions included potentially privileged material nearly 4 weeks ago. Wayfarer party later informed counsel for Miss Lively that they would adopt the case privilege logs, and the Wayfarer party had ample time. So he just completely skips over the part where Wayfarer Kevin Fritz says, we never heard it. We talked about this back then, and we never heard that they still had issues. So he's saying, oh, they knew about this way back then, and they had plenty of time, but completely just ignoring the fact that they said, we talked about it. We thought it was done. We had no idea there were still issues. So they weren't preparing all this time based on the conversation that they had back then. So after noting that the production included communications with certain of the Wayfarer parties, Wayfarer parties counsel, and stopping review, counsel for Miss Lively notified counsel for the Wayfarer parties. Miss Lively's counsel deleted the initial production for their own document review platform. So he's saying, we saw that it was privileged. We deleted it. We don't have it anymore. Trust me, bro. Now, this sentence here, it like literally made the hairs in the back of my neck stand up when I read it. I'm not going to lie. And what does this sound like to you? Let me read this, okay? It is beyond dispute. Well, let me do the sentence before. While it is not clear whether the Wayfarer parties retained any of the initial inadvertent production. So he's talking about the part that was mistakenly sent, okay? The privileged stuff. Look at what he says. It is beyond dispute that they have been aware of the possibility that their counsel's communications were implicated by Miss Case and Miss Koslow's productions since July 17th at latest. Do you guys understand what he's saying here? By implicated, he's saying, at least the way I'm taking it, is that something in this stuff that was sent to them of Case and Koslow's things implicated or has, the possibility that their counsel's communications were implicated. So Brian Friedman, who they keep pointing at and subpoenaing and blaming everything on, they're saying, it's possible that your communications with were somehow, you were somehow implicated by these productions. So implicated means like it insinuates that, oh, there was something you did wrong here, possibly. It's tricky how he's saying it. So in my opinion, what he's doing here, and he's like, hey, we got these, we got these things we weren't supposed to get. And there could have been something in there that said that you said something you shouldn't have. Do you guys understand what I'm saying? I see some of you saying you don't get it. But what I think is happening is they're trying to make the world believe that there's something there and they're hiding it. That the reason that they're fighting so hard to say this is all privilege is because there's something in there that implicates Brian Friedman. And so to me, that's what they're doing. They're trying to cast doubt so that we're like, oh, there is something there that implicates Wayfarer Council. And that's why they're hiding it. But to me, it reminds me of this whole thing with, yes, PR stunts. This whole thing with Blake's deposition transcript. Remember, they threw such a fit saying, so you're making us have to say we want this sealed to make it look to the world like she has something to hide. And so she either has to hide this and look guilty or have it exposed. And I think they got that idea from this. And that's what they're trying to do. They're trying to make them bring this out of privilege or look like, oh, you're hiding some communication with Brian Friedman that implicates him. Implicate is makes look guilty. Do you understand what I'm saying? I could be way off, but that's the feeling I got when I read this paragraph. That they are trying, because they know we're all reading this, they're trying to make it look like, something that we saw, and you know it because you saw it too, implicated you. So it's just ugly lawyering, in my opinion. So so they're either left saying, you look suspicious, or all right, then show us you didn't do anything wrong. And it's so infuriating. But I don't believe it for a second because I saw the rest of the stuff there. So you got to take it all as a whole instead of looking for one little gotcha moment that you can twist. But that was one of the big things that I got out of this. And so he goes on and says, this thing at the end makes me so mad. So we saw that this email was subpoenaed. I believe this was Brian Friedman's email, this Skyline agency. So this was being fought in a different state because subpoenas are supposed to be fought in the district where they are served. But of course, like every other subpoena that's been served anywhere else, they keep fighting to get it back under Judge Lyman. So they fight with these rules. They mention which rule? 45F. And so they have withdrawn their opposition to the motion to transfer. And now that subpoena is coming under Judge Lyman. So good luck, Brian Friedman. If I'm remembering correctly, and that is his email. Am I remembering correctly? If I'm not, somebody correct me, please. I think that's the name of his email company, but I'm not sure. Or the one who was behind the website. I feel like it's connected to Brian Friedman, so I might be saying this wrong, so don't quote me on this. I forgot to look it up and write it in my notes. So if somebody knows for sure, please say so in the chat. Otherwise, don't repeat me on this because I'm not 100%, but I feel like it's related to his email or to his website, but something to do with Brian Friedman. Okay. And he ends with his nasty little footnote that says, in any event, Miss Lively anticipates that she will likely reply to Miss Koslow's opposition. So they are not going to let this go. Next, we have the response from Case and Koslow's attorney. Okay, thank you. Thank you for verifying. They made the website. Okay. All right. So that is now coming under Judge Lyman's jurisdiction. Okay. Thank you also for verifying this. Skyline is for the lawsuit info website that was subpoenaed. Koslow's name is on that privilege log. Thank you. Okay, so then this is the response. They said that they were going to revise that privilege log. So this is the letter that accompanies the revised privilege log. And they mention a couple of things about it. They organized it differently. And it's not on this one, but I think it's on the previous letter. I forgot to mention on that letter that Katie Case, they had originally put the date of her resignation when she left HAG. They had originally gotten that wrong. And so they also correct that on here. And we're not going to go through this. This is actually just one page and it's long. So this is what a privilege log looks like. We heard it described earlier. So it's basically an inventory of all things privileged. And then the opposing counsel can take a look and say, we don't think this is privileged. We need to compel this, like is happening right now. So this is the new privilege log, how it's supposed to be. And of course, this is the second strongly worded letter that Mike Gottlieb wrote. We're not going to consider this. It's a lot more ick, and I've already been on for too long. So, and I prefer to respond, or I prefer to cover this after it's been responded to, so that I have something to say in opposition to the claims that he makes, because his claims are always so wildly unfounded and the case law is always wrong, as we have seen. So we're not going to cover that one, but that one did come out as a response. And so probably on Monday, there will be a response back to that. And this is just, sorry for the jump scare to see this face. Doesn't it just, like, now that you know more about this man, when you see his face, doesn't it just give you like major ick? But this has nothing to do with anything. I just accidentally came across this when I was searching something else. And I was like, oh, interesting. This is back from 2021. Misleading Michael. Yes, that's what we should call him. So he's been working with this firm for a long time. This Wilkie that Mike Gottlieb is part of, they represented him when he was doing some big business deals. So that was just a little tidbit. I thought we should keep this in mind if something more comes up about them. We just never know. I have to sleep. I don't want to see demons in my bed. Okay, let's close with this then. So this is my interpretation of them not looking at the documents. It's satire. Don't subpoena me, Ezra and Michael. But anyway, thank you guys so much, even though it's so late, for coming on and supporting, and for the super chats. I should go through those again one more time just to make sure I didn't miss any. Thank you so much, Quintong, and Kyle and Kyle and Kyle and Kyle. There were more. I don't know where they went. They didn't go to the saved. Sorry about that. But thank you guys so very much, and have a wonderful rest of your weekend.